Hey y'all, Rob here with ATX Legal, here with the first part of the Travis County Assault Family Violence Guide, and this part is going to talk about arrest and bond, because of course the first thing that you need to worry about after you've been arrested is getting out of jail. And there's two common situations that are going to happen, and we'll discuss each in turn. And the first is if you are arrested on the spot. So if you've stayed on the location, someone calls the police and they've decided to make an arrest, you'll get taken downtown to the jail down on 11th Street, and you'll be booked in. Now, for DWIs and other nonviolent misdemeanors, it's very common to get a personal recognizance bond. That's a free bond where the judge will okay it. You might not even have to get an attorney to get that PR bond. It's a little less common in assault family violence cases because judges don't want to release someone who goes out and causes more injuries later. That will be on the news. It won't be a good look for the judge. And of course, we just want to prevent that kind of thing from happening. So it can be a little bit more difficult to get a PR bond, but not impossible. You are going to benefit at this stage by hiring an attorney quickly because an attorney will most likely be able to get you released sooner. Now, there's going to be a number of factors that determine whether you are going to get a PR bond. And the first factor is often going to be what the complaining witness says. Now, the complaining witness is just a legal term for the person who is accusing you of a crime or accusing another person of a crime. They're called the complaining witness. And the judge is going to want to hear their feedback. Are they fearing for their life? Are they worried that if this person gets out, are they going to come right back to them and possibly cause more injuries? So getting that person's input is going to be important. A lot of times the complaining witness will say, no, I don't fear for my safety. I want him out. I didn't even want him arrested in the first place. And that's going to be a positive factor as far as getting a PR bond. Another factor is going to be criminal history. Have you ever been accused of domestic violence in the past or any other violent charges? Is there drug use? Things like that on your criminal history will affect your ability to get a PR bond. A third factor is, of course, just going to be the facts of the case. Were there severe injuries? Were there barely any marks? Were you provoked somehow? Was there possibly self-defense involved? All these factors can definitely play into whether you get a PR bond. If the case is charged as a felony, and there are several ways it can be charged as a felony, and we'll get to that in a later chapter, you're going to be less likely to get a PR bond. Although with an attorney, you certainly can get a PR bond, and that's something that's going to vary on a case-by-case basis. If a PR bond is not available, a judge might set bond and you could be eligible for a surety bond. Now, depending on the case, this might be something where it's set at $5,000, $10,000 on up. I've seen $100,000 bond, and if you want to get out, you'll need to go through a bondsman where you'll pay a 10% fee usually. You won't get that money back. It's not a free bond like a PR bond. It does cost, and you'll be beholden to that bondsman for the remainder of the case. And whether you get a surety bond or a PR bond, the judge may impose a waiting period. This is like a cooling off period of 3-4 days where you won't be released until a certain date. And again, that's just to allow the complaining witness or the accuser to get their things together, to find a new place if they are living together, and to basically get safe before the accused is released. The second main scenario is when the person who is accused of domestic violence has left the scene. So the police show up and the person who is the alleged victim is there and gives a statement, but the person who is accused is gone. And what will typically happen in that situation is the police will try and locate him that night. Maybe they'll give him a call. They'll see if his vehicle is in the parking lot or the driveway. But if it's not, what they'll do is go ahead and get a warrant for arrest. So there will be a warrant issued. That person may or may not know about it. Sometimes you'll find out through friends or family or someone else who was there, or sometimes the complaining witness will call and say, hey, there's a warrant out based on what happened, so they'll know about it. Other times, you just won't even know about it until perhaps you're pulled over by the police at a later date, or if they come knocking on your door to execute that warrant, and you'll be taken to jail. But if you do find out about the warrant, the best practice is to hire an attorney and to set up what's called a walkthrough. Now, a walkthrough just means you'll process in, you'll get your fingerprints taken, you'll have your mugshot taken, but the bond is already signed, or the judge has already agreed to sign the bond before you've shown up, so that you can minimize the amount of time you spend in jail and sort of minimize that uncertainty as to whether you will or will not be released. So if you do know about a warrant, if you're watching this video and a warrant's been issued and you don't know how to handle it, give a call to an attorney, ask to see about setting up a walkthrough, and that's something that you would want to talk to the attorney about before you went to the courthouse. You're better off talking to an attorney before you turn yourself in. In previous years, if you know someone or if you've had experience with doing walkthroughs, you could have gone through a bondsman and done a walkthrough with just a bondsman. Now the Travis County Sheriff's Office is requiring that you hire an attorney before setting up a walkthrough. So again, if this is you, if you're in a situation where there's a warrant issued, just give a call to an attorney. We give free consultations. A lot of criminal attorneys give free consultations. Your best bet is to talk to an attorney and see what the best course of action is for you. None of this is legal advice, but if you do want legal advice on your particular case, you can visit us at atx.legal. We also have some more videos in this series, and the next video is on bond conditions, so it's related. So click on our YouTube channel if you need some more information.